lakhs was awarded uh, by the Supreme Court. But the champion of champions is, of course, Dr. Kunal Saha. I hope everybody is aware. Whether you know treatment of malaria today or not, you have to know about Kunal Saha. But do you also know that when he first filed the case for compensation in National Commission, his case was dismissed, that there is no substance in this case. The doctor had given Depo-Medrol in a higher dose than is usually used. Patient had toxic TE and toxic epidermal necrolysis. 50% mortality worldwide is in the best of centers. And National Commission, in its wisdom, said no negligence. Problem arose in between. Judicial Magistrate First Class in Calcutta ordered 3 months imprisonment to the doctor. So now National Commission, a consumer court had said no negligence, and 3 months rigorous imprisonment was awarded for criminal negligence in this case. So both these cases were taken to Supreme Court, and Supreme Court ordered that fine, there is no criminal negligence, but there is a case made out for civil negligence, and referred the case back to National Consumer Dispute Redressal Commission, which ordered 1.73 crores as compensation, and 10% of this was to be paid by Dr. Kunal Saha, because they said there is contributory negligence of Dr. Kunal Saha in interfering with the treatment of his wife. This Kunal Saha ji could not digest, so he again went to Supreme Court, and now the Supreme Court awarded 6 crores 8 lakhs 550 along with 6% interest from 1997 till 2013. Total came to 11.5 crores. To date, this is the maximum compensation which has been awarded. IMA wanted to implead, was denied. A revision petition was filed in Supreme Court. This was denied. There was a trickle-down effect after this judgment. A state commission, West Bengal, ordered 73 lakhs compensation for a patient's death. How did the patient die? Patient was admitted after an accident. He was operated. Everything was fine. In between, at night, one day, he decides to hide from the nurses, go onto the roof of the hospital, and jumped to his death. So the negligence of the hospital, according to the state commission, was that he was in your custody, and it is because of your negligence that he has died. Something similar to what the advocates initially, Dr. Bhullar initially alluded to that case where electrical shock killed a patient and the hospital was held liable. The problem is, it's all right when it is a compensation of 2 lakh, 3 lakh is being awarded, but with no limit on compensations, and in what case, what amount is going to be awarded is not in your hands. It is dependent on what the person's earning capacity was. Supposing the same shock had been received by an NRI who may be earning in lakhs of dollars in US, you had it. You, your family, your neighbors, your town will not be able to pay the compensation. Abhishek Aluwalia, I've already referred to this judgment, and now the Indu Sharma versus Apollo Hospital National Commission has ordered 1 crore 10 lakhs. The 10 lakhs is as punitive damages, and 1 crore. This is a case, primary infertility, 88 kg lady. She was admitted for a long time and had premature delivery. The child had asphyxia and later on developed a lot of neurological problems. So in this case, the issue arose that you did not maintain the CTG records, or the CTG records were tampered with, and finally 1 crore 10 lakhs has been awarded. All right, that is Apollo Hospitals. Here is state of Tamil Nadu, a government hospital delivered a premature baby, treated the premature baby, everything was all right. After some time, it was found the baby could not see properly, and they realized the baby had retinopathy of prematurity. The hospital and the government was penalized 1 crore 73 lakhs for not referring the premature baby to be seen by an ophthalmologist. This is a government hospital now we are talking about. Please remember, the compensation awarded can be much more than what has been asked for originally. Doctors come to me and tell me, यार लाख रुपए दी गल हैगी है, डिस्ट्रिक्ट फोरम ने लाख रुपए का अवार्ड दिता है, दे देने हैं, गल मुकाने. Mind you, if the patient is going to court for in appeal into the state commission and you are not contesting the case and the state commission in its wisdom decides to award compensation which may not be the 2 lakhs the person has asked and has been given 1 lakh, which may be much more. It is up to the court to decide how much more. Look at this case. A compensation of 3,200 rupees only was awarded against the doctor. He went in appeal to the state commission. State commission said no compensation, overruled the district forums. The patient now went to national commission. 3,200 rupees was awarded, under which the doctor had gone for appeal. The national commission says imposed fine of 5 lakhs. And this has to be recovered from the salary of doctors. There is another very strange thing. If you go into the judgments, various judgments give interest, decisions on interest, varying from 6% to 18%. Some judgments say 9%, the person has to pay, let us say 5 lakhs, 30 days from today, and in case the payment is not made, 9% interest is to be charged from that date. All right, I can understand that. But the judgments now are coming 18% to be paid from the date the case was originally filed. The case was filed in district forum, it had went to state commission to national commission. National commission has taken 14 years to decide a case. How is it the doctor's fault? And the interest component is much more than the compensation you are awarding. And till date, I have not found anywhere whether this interest which is awarded is simple interest or compound. Someday when I come to know, maybe. But let us look in this era of unlimited compensations. I hope you know Rajan Pillai. He was chairman Britannia Industries. And he was arrested in an economic offense fraud and he was kept in Tihar jail. And this gentleman already had cirrhosis of liver, he had already had blood vomiting earlier, and he had been treated by an endoscopist or a gastroenterologist in Delhi with sclerotherapy. So when he was arrested, during his arrest, he made a written request to the jail authorities that I may be permitted to be treated by my specialist. This request was specifically denied after 3 days, and 4th day, this gentleman was found dead in his cell after having had a bout of hematemesis. Now, this is a person in custody of the state. The person is chairman Britannia Industries. If we calculate compensations as are calculated against doctors today, what amount of compensation would have come to mind? What was he paid? He was paid 10 lakhs. Hospital is responsible for any doctor who's doing work in your nursing home. People have this kind of defense which they try to put in courts कि डॉक्टर साहब हमने तो केवल अपना नर्सिंग होम दिया है, वो ऑपरेशन तो उन्होंने आके किया है, उनकी प्रॉब्लम है, उन्होंने मॉप छोड़ दिया अंदर. Nothing doing. Whether the doctor is empaneled with you, whether the doctor is salaried employee of yours, error which occurs because of the doctor, you are equally a party. The nursing home or the hospital cannot deny responsibility for actions of their anesthetists or surgeons. And one of the landmark judgments in this case was Savita Garg versus National Heart Institute, where earlier doctors used to take this plea, you have implicated the hospital, but actually this is the fault of the doctor and you have not implicated the doctor, so the case should be dismissed. And this judgment of Supreme Court very clearly mentioned that nothing doing, it is up to the hospital to bring the doctors to give their evidence. It is not, if they have not been impleaded as a party, this will not be ground for dismissal. Another very interesting thing, discovery rule. Everybody is aware that consumer case can be filed within 2 years of the cause of action. But this discovery rule says this lady, she was operated for cholecystectomy in 1993. In 2002, it was found that she had a bulb which was left inside. It remained there for 9 years. Case was filed in 2004. And the courts agreed that the cause of action starts from the time when she found out that a negligence had been committed on her. Whether it was committed 10 years ago is not of concern. My problem with this arises is, how long do I keep my medical records? Because if I go by MCI recommendations or consumer courts or civil courts, 3 to 5 years would be the maximum. But here we have cases where 15 years later, the records are being asked for, and I fail to understand how this is to be addressed. Another example, this is 2015, Dr. Shakuntala Banale. Again in this case, birth asphyxia had occurred, neurological deficit was there. Case was filed 5 years after delivery. Doctor took the plea that MCI regulations require records to be maintained only for 3 years. Court could not be told what the APGAR score was because the case had been filed 5 years later, that the child did not cry after delivery or not. None of this was told to the court because the records were simply not available. So negligence was awarded. And discovery rule and consent both. Patient had deformity of left leg, multiple operations since 14 years. The doctor wanted to take out the patella and replace it with a steel one. They refused to give consent for this. Later, he decided to do a different surgery which was called quadriceps plasty. Consent was given for this. Everything was all right. 2-3 years down the line, another doctor told them that your patella has been removed. So they went ahead and filed a case after another 2 or so years. One, that the consent was not given for removal of the patella, and the second important issue which arose was this was being filed after the delimitation period. The delay was condoned and compensation awarded. You have to record the fact that consent has not been given to operate, especially gynecologists. Patients refuse surgery. In fact, this Hindu Sharma versus Apollo Hospital case had very specifically mentioned that the patient had refused cesarean, and despite that, the 1 crore and 10 lakhs has been awarded. So basically, if a patient is not agreeing for surgery, please document the consent. And please document whenever you want me to stop, sir. I'll be carrying on otherwise in my... Sterilization without consent during a cesarean is negligence. But let us look at this case, M.K. Varghese versus San Jock Hospital, National Commission 1992. If a doctor has performed sterilization during cesarean finding that any future pregnancy could be dangerous, the doctor is not negligent. But after that, we have cases from State Commission. After a National Commission judgment, we have cases from State Commission saying that this is negligence. And of course, the most